The water started to rise on August 28th. Our home was completely flooded by August 29th, 2017. 2 years later, it happened again.
Richie Devillier and his family have been farming their land in Winnie, Texas for nearly 100 years. They grow rice, have an olive orchard, and raise cattle. At least, they used to.
My great-grandfather came and settled this property almost 100 years ago. He raised my grandfather here. My grandfather raised my father here. My father raised me here. And I raised my son here. This land means everything to my family. Sometime when my father was growing up, they built the freeway on our property. When they improved the highway, expanded it to 3 lanes on each side, they raised the roadbed an average, my understanding, of around 18 inches. And then they put 32 inches of barrier poured, cast in place, and it functions exactly like a dam.
Richie's grandfather chose this land to homestead specifically because of its elevation. When it rains, the water has got to go somewhere. For as long as anyone can remember, the water flowed south, away from his land and towards the Gulf. But in the early 2000s, Texas decided to elevate a nearby highway and build a concrete median down the middle. Now, whenever a major storm hits, Richie's land is flooded for days.
Hurricane Harvey and its torturously slow march along the Gulf Coast of Texas.
Tonight, along the Texas Gulf Coast, utter devastation. The eye of the massive hurricane moved.
We went and my parents brought them to our house to stay because we thought we would be safe from the flood here. And overnight, the water started coming in the house. And when we got up the next morning, we were almost knee deep. We had 900 acres here, completely submerged. Also, our neighbors, the neighborhood down the street, everyone was in the same lake at that point in time. My house was flooded. Our multiple vehicles were flooded. My equipment was flooded. Animals that weren't already dead, drowned and floating, had been standing in deep water for several days. And when that happens, their hair will start to slip, and then they will just lose all energy. And we tried to move cattle that were standing in the floodwaters to higher ground, and they wouldn't go. You just could not herd them. They were spent, done.
The highway median turned into a dam and blocked floodwaters from draining away. For days, their farm was a lake. The flood destroyed his family's crops and orchard. It killed their livestock and horses and damaged their homes and farming equipment. Just 2 years later, Hurricane Irma came through and flooded the Devilliers' property all over again.
So after the second flood, I really felt convicted. I knew what my task was. We had to get this problem solved. We had been wronged by the state twice now. We struggled to find an attorney that would help us, but we couldn't afford anything because we had basically lost everything at that point in time.
Now the Institute for Justice is working with Richie to hold Texas accountable for the damage it caused to his and his neighbor's land.
My father was born and raised on this property. He farmed this land all his life, raised his children, saw his grandchildren grow up here, and was displaced by this flood that was caused by the government. And he died in Oregon, never being able to come back home. The flood that the government caused took so many things from us that can't be replaced. We just want them to replace the things that can.
Today on Legalese, we will be wrapping up the Supreme Court case of Devillier v. Texas and discussing the court's holding that Devillier is entitled to seek just compensation under the Takings Clause when the state of Texas flooded his property. Hey, greetings everybody, and welcome back once again to Legalese. Now, as always, I am your host, Bob, and I want to thank you all so much for joining me here today. And if you happen to be new to my channel, let me especially welcome you. This is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, I just want to remind you guys real quick, if you want to find out more about our show, you can go check out our homepage over at legalespodcast.com. And if you want to get notifications whenever I post new content, and I don't just do videos on YouTube, I write articles over on Substack. I post my show to alternative platforms. There's an audio-only version I do as well. And if you want to get notifications for all of those things, or just curated notifications for some of those things, either way, all you have to do is head over to legaleshow.com. There you can subscribe to our newsletter and get those notifications sent right to you. All right, well, we have a lot to get to today, so let's just fucking jump in, shall we? So today, as I alluded to right off the top, we are going to be discussing a case that was part of my Supreme Court roundup, and this is the case of Devillier v. Texas. And because it's been part of my Supreme Court roundup, this means, of course, that we have been closely following it. I've already made several videos devoted to just this case, and today's will be the last one as the Supreme Court has issued its opinion. And it is, as I had predicted, a big win for the Fifth Amendment and for property rights in general. Though, I must say that I am more than a little disappointed about a part of the case that the court didn't even address in the opinion, but we will be getting to that grievance a little later in the video. First, why don't we quickly review the case that came before the court and discuss what the court did hold. Now, this decision was a fantastic one in that we once again saw the court unanimously uphold a private party's right to just compensation under the Fifth Amendment's taking clause, which says that private property shall not be taken for public use without just compensation. And between Tyler v. Hennepin County, Sheetz v. El Dorado County, and now Devillier v. Texas, we have 3 takings clause cases in a row where the court has sided with property rights, which is a great thing. Now, in this case, Richard Devillier and more than 120 other petitioners who owned property north of U.S. Interstate Highway 10 between Houston and Beaumont, Texas, would sue Texas. And the dispute arose after the state of Texas took action to use portions of I-10 as a flood evacuation route. They would install a roughly 3-foot tall barrier along the highway median to act as a dam, and when subsequent hurricanes and storms brought heavy rainfall, the median barrier performed as intended, keeping the south side of the highway open, but it also flooded the petitioners' land to the north, causing significant damage to their property. Now, Devillier would file suit in Texas state court, and he would allege that by building the median barrier and using his property to store storm water, Texas had effected a taking of his property for which the state must pay just compensation. And those more than 120 other property owners would all file similar suits. Now, Texas would remove this case to federal court, where they would consolidate it into a single proceeding with one operative complaint. And this operative complaint includes what is known as an inverse condemnation claim under both the Texas Constitution and the Takings Clause of the Fifth Amendment. Now, an inverse condemnation claim is a cause of action against a governmental defendant to recover the value of property which has been taken in fact by the governmental defendant. And as relevant here, Texas would move to dismiss the federal inverse condemnation claim, arguing that a plaintiff has no cause of action arising directly under the Takings Clause, and the district court would deny Texas's motion, concluding that a property owner may sue a state directly under the Takings Clause. However, the Fifth Circuit would reverse, holding that the Fifth Amendment's taking clause as applied to the states through the 14th Amendment does not provide a right of action for takings claims against a state. And to get right to the primary holding in this case, the court would hold that Devillier and the other property owners should be permitted to pursue their claims under the Takings Clause through the cause of action available under Texas law. The Takings Clause of the Fifth Amendment states that private property shall not be taken for public use without just compensation. The court has explained that a property owner acquires an irrevocable right to just compensation immediately upon taking. And because of the self-executing character of the Takings Clause with respect to compensation, in accordance with the precedent set in Nick v. Township of Scott and Evangelical Lutheran Church of Glendale versus County of Los Angeles, Texas does not dispute the nature of the substantive right to just compensation. This case presents only a question regarding the procedural vehicle by which a property owner may seek to vindicate that right. Now, going to the majority opinion. Now, constitutional rights do not typically come with a built-in cause of action to allow for private enforcement in courts in accordance with Egbert v. Boole. Instead, constitutional rights are generally invoked defensively in cases arising under other sources of law or asserted offensively pursuant to an independent cause of action designed for that purpose, such as 42 U.S.C. Section 1983. Now, Devillier argues that the Takings Clause is an exception, and he relies on the First English Evangelical Lutheran Church of Glendale v. County of Los Angeles to assert that the just compensation requirement of the Takings Clause is indeed self-executing, and that statutory recognition is not necessary for a takings claim because they are grounded in the Constitution itself. So, in other words, the Takings Clause creates, by its own force, a cause of action authorizing suits for just compensation. So, as I just mentioned, Devillier relies on First English and other cases to argue the Takings Clause creates by its own force a cause of action for compensation, but these cases do not directly confront whether the Takings Clause itself provides the cause of action. And because the cases that Devillier cites do not directly confront whether the Takings Clause provides a cause of action for just compensation, First English itself proceeded under a state law cause of action. Now, Devillier would also point to several takings cases where property owners sought injunctions to prevent the government from interfering with their property rights, such as obtaining easements or imposing zoning regulations. But because none of these cases relied on Section 1983 for a cause of action, he reasons that those cases must have proceeded directly under the Constitution. But the court would say the mere fact that a takings clause provided the substantive rule of decision for an equitable claim in those cases does not establish that it creates a cause of action for damages, a remedy that is legal and not equitable in nature. Now, the court would go on to say that, that said, the absence of a case relying on the takings clause for a cause of action does not by itself prove that there is no cause of action. It demonstrates only that constitutional concerns do not arise when property owners have other ways to seek just compensation. The court says that our precedents do not cleanly answer the question whether the plaintiff has a cause of action arising under the Takings Clause. The court goes on to say that this case does not require us to resolve that question. The question presented asks what would happen if a property owner had no cause of action to vindicate his rights under the Takings Clause. And it would be imprudent to decide that question without satisfying ourselves of the premises that there is no cause of action, and our constitutional system assigns a state officer a coordinate responsibility to enforce the Constitution according to their regular modes of procedure in accordance with Howlett v. Rose. The court's opinion goes on to say that it therefore looks to the good faith of the states to provide an important assurance that this Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land, in accordance with the precedent set in Alden v. Maine. Now, states and their officers are also bound by obligations imposed by the Constitution. And going back to the majority opinion, the premise that Texas left Devillier with no cause of action to obtain the just compensation guaranteed by the takings clause Clarence Thomas claims does not hold. And Texas state law provides a cause of action by which property owners may seek just compensation against the state. And as Texas explained in oral argument, its state law inverse condemnation cause of action provides a vehicle for takings claims based on both the Texas Constitution and the takings clause. And although Texas asserted that proceeding under the state law cause of action, it would require an amendment to the complaint, and it also assured the court that it would not oppose any attempt by Devillier and the other petitioners to seek one. And it is here where I really begin to take issue with the court's holding in this case, because it just simply neglects the underhanded means by which Texas went about screwing Devillier of his just compensation. And the fact that Clarence Thomas will say we assume these states will act in good faith to honor the obligations that they are bound to by the Constitution is ridiculous, because the whole reason this case exists at all is because we know for a fact that Texas acted in bad faith to squirm its way out of its constitutional obligations. Now, what happened when Devillier filed a takings claim in state court? Texas removed the case to federal court under 28 U.S.C. section 1441, which allows defendants to remove to federal court any civil action brought in a state court of which the District Court of the United States have original jurisdiction. And they then would persuade the U.S. Court of Appeals for the Fifth Circuit to dismiss the case on the ground that it could not be brought in federal court because Congress hadn't enacted a statute allowing property owners to do so. And if allowed to stand, this maneuver would create a catch-22 under which these states can evade a takings liability by removing a case to federal court and then having the case dismissed. So in plain terms, Devillier brought this case in a Texas state court under a state cause of action. Texas refused to let the case be heard in a state court by immediately removing the case to federal court. Then, when they came before the Supreme Court, Texas's argument was, well, if Devillier had a takings claim, he should have sought a remedy in the Texas state court, which is precisely what he did. And Texas is simply victim blaming here. Now, the fact that the court just completely overlooks the fact that Texas demonstrably acted in bad faith is a very frustrating fact. And they never even address the conflict of 28 U.S.C. section 1441 and the way it allowed Texas to create this catch-22 that leaves the door wide open for states to do this same bullshit again. And this is also very frustrating. And why the court believes that Texas will honor its claim to bring this case in a state court seems to ignore the fact that the refusal to hear this case in a state court is the reason this case came before the Supreme Court in the first place. And it is frustrating in the extreme that this one essential issue remains unclear. That is, whether, on remand, Devillier and the others will be able to pursue the Texas law cause of action in a federal court, or whether they must do so in a state court. Now, if it is the latter, could Texas once again simply remove the case to federal court and then once again argue that the case must be dismissed because there is no proper federal cause of action? So, to my mind, the requirement that Devillier and the other property owners should be permitted to pursue their claims under the Takings Clause through a cause of action available under Texas law seems to hopefully preclude the possibility of their being removed and dismissed for procedural reasons. But I don't know, perhaps I'm missing something here. I really wish the court had been much more clear on this point. And perhaps this catch-22 won't recur in this case, either because of the substantive takings issues that will now be fully litigated in federal court, or because the plaintiffs will be able to pursue their claims in a state court, and Texas will choose not to remove again, or such attempts at removal will be rejected, but this could very easily arise again and again in other cases. It would have been much better if the Supreme Court had simply ruled that the Takings Clause is self-executing. The clause makes no distinction between legal and equitable remedies for violations or between offensive and defensive uses of the constitutional right in question. Instead, the presumptive remedy of just compensation is built right into the text. And such a clear textual command overrides any possible implicit law equity distinction. And frankly, it would be perverse if the state or federal government could simply negate a takings clause by simply failing to enact a specific statute to enforce it. And even if previous Supreme Court precedents don't squarely decide this issue, several of them, including First English, do strongly imply that self-execution is the rule. For example, as Justice Thomas would note in the 2019 Nick decision, he specifically refers to, quote, the self-executing character of the takings clause with respect to compensation, end quote. Now, additionally, even if the property owners are allowed to pursue claims in state court, it is important for victims of violations of federal constitutional rights to have federal court access as well, and this is a principle that was upheld by the Supreme Court's important taking clause ruling in that case of Nick v. Township of Scott. Now, while I do think the courts upholding the takings clause unanimously is a great thing here, considering this is a topic that usually splits the court along ideological lines, and really the fact that, as I mentioned earlier, this is now the third takings case in a row where the government has unanimously sided with individuals and their private property rights over state claims of sovereign immunity. And those other cases, as I mentioned, were last term's Tyler v. Hennepin County and this term's Sheetz versus County of El Dorado. And that these three decisions have been so strongly in favor of property rights is both notable and commendable. Though, while the court did explicitly say that the petitioners should be allowed to pursue their case in state court, which really is an ideal outcome in this limited instance, I really wish they would have done more to make the point that they should always be allowed to bring such a case in state court. And in a ruling that would apply to other people other than those who were party to this particular lawsuit. But, as Justice Thomas would write in Devillier, this case, therefore, does not present the circumstances in which a property owner has no cause of action to seek just compensation. On remand, Devillier and the other property owners should be permitted to pursue their claims under the Takings Clause through a cause of action available under Texas law. And the opinion of the court ends with the following court order. The judgment of the Court of Appeals is vacated, and the case is remanded for further proceedings consistent with this opinion. Now, the most crucial aspect of this case was Justice Thomas's brief summary of how constitutional rights can be litigated in federal court. He says that constitutional rights do not typically come with a built-in cause of action to allow for private enforcement in court in accordance with Egbert v. Boole, but instead constitutional rights are generally invoked defensively in cases arising under other sources of law or asserted offensively pursuant to an independent cause of action designed for that purpose, such as 42 U.S.C. Section 1983. Now, though this case, as I've already mentioned, does not turn on this matter, Justice Thomas nonetheless describes the sword-shield dichotomy that was actually recently advanced during the 14th Amendment litigation in the Trump v. Anderson case. And that is to say that when a constitutional right is asserted offensively, it must be brought pursuant to an independent cause of action designed for that purpose, such as Section 1983. But by contrast, a constitutional right can be invoked defensively without a cause of action in a criminal prosecution or some other state enforcement action. And this simple dichotomy will reconcile Griffin's case in the case of Jefferson Davis, and it also makes sense of much of the court's remedies doctrine. Now, for people who want to learn more about the sword-shield dichotomy, I will link to some great articles that go into that discussion on the show notes page for this episode. And if people would perhaps like a video discussing that topic, let me know in the comment section of this video. If I get enough responses, I'd be happy to make a video on that topic. However, in this particular case, where Justice Thomas cites Egbert v. Boole, this case is really only concerned with a limitation on the Bivens exception and the remedy created therein. And that case did not speak to the offense-defense or sword-shield dichotomy. And Thomas only cited Section 1983 itself, which does not directly support the proposition at issue. Now, regardless of these other quibbles that I have with this decision, the court has clarified the law here in an important fashion, and I have to say, Devillier may be the cleanest statement of this principle in all of the court's precedents, and I mean ever. However, this ruling was, at least in my humble opinion, far too narrow. The court should have, but did not resolve the issue of whether the takings clause is self-executing, allowing property owners whose land has been taken to bring cases in federal court, even in the absence of a specific federal statute authorizing it. The Supreme Court decision does, however, overturn, and we should be very grateful for this, the extremely dubious Fifth Circuit U.S. Court of Appeals ruling that would dismiss the plaintiff's case entirely. And at least for the moment, it also negates Texas's Catch-22 attempt to get rid of the case by removing it to federal court and then getting it dismissed on the grounds that there is no federal cause of action available. And as Richard Devillier's attorney, Robert McNamara, of the Institute for Justice would very succinctly put it, there is not an asterisk next to the Fifth Amendment that says the government doesn't have to pay just compensation if it doesn't want to. The Supreme Court has repeatedly affirmed Americans' rights to just compensation as an inherent part of the Constitution. It cannot be ignored or circumvented by the government or the courts. All right, well, that is really all I got for you guys here today. Thank you so much for tuning in to Legalese. And of course, as always, if you would please do all of those things that help to trigger Al Gore's rhythm, I would be very grateful. If you like this episode, go ahead and hit that like button. If you disliked it, you can go ahead and hit the dislike button if you want to be a dick. But also, don't forget to subscribe to the channel so you always get notifications when new content comes out. And don't forget to leave me a comment down below. Let me know what you thought about the episode or the topic we discussed or whatever. I really do enjoy getting your guys' thoughts on the content I make down in the comment section and interacting with you as much as I can. So if you would do all of those things for me, I would be very grateful. And so until next time, this has been Bob for Legalese, talking about Devillier v. Texas, and of course, as always, Carthago delenda est.